And here we go. We're live again. And let's go to the videotape. Okay. You're listening to DFNUVS. You are listening to DFNUVS. I believe it is now 11:32 a.m. They may be breaking for lunch. Maybe on a break as we speak. We are live at the Diddy trial. Give you some light. Turn on the lights of heaven, Lord. Shine on me. Turn on the lights of heaven, yo. Shine on me. Shine on me. Turn on the lights of heaven, y'all. Shine. How do I look? Do I look good? All right, let's get down to business. I wanted to finish off yesterday's points. Once again, we have to make it very plain and very clear that this is not against Paz Ventura. It's a matter of the interests of justice and fairness. This is a federal trial. I found out yesterday that the Manhattan DA turned this down for state criminal charges. And I believe it was largely due in part to the fact that all of the crimes, all of the abuse, all of the sexual assault allegations are past the statute of limitations. So the federal courts took up the case in the matter of interest, in the interest of justice and fairness. However, the only way that he could be tried for cases beyond the statute of limitations is through a RICO Act. So now RICO Act has been on the books, I believe, since the 70s, but made popular during the John Gotti trials and other gangs that would come up past that point. So that they could include like clandestine operations going on behind the scenes. We were always able to get the culprits, but not the boss of the culprits, the boss of bosses. Now, does Diddy fit that role of boss of bosses? Not quite. Not hardly, actually. So today's theme, continued from yesterday, is if the RICO Act does not fit, you must acquit. If it is a maybe in terms of Diddy may have done it, then there is reasonable doubt. Now, there's no reasonable doubt on the physical assault that's on video. There's no way he can deny that. And there's no way that that's not a crime. It's just that the statute of limitations has run out. So the federal court can pick it up and toll the statute of limitations. That means extend the statute of limitations or disregard it altogether. If you can prove that there was the element in Bad Boy, record company, of crime, and the part that you also have to prove, which they have not proved, is that the people who Diddy was bossing around had knowledge of Cassie being sexually trafficked. I don't like to say that word on YouTube. That she was engaged in messy stuff. How about that? How about that? And that messy stuff is criminal under the RICO Act. So let's get right back to if it's a RICO Act, you must acquit. Now, what we understand from the initial testimony of Ms. Ventura is that we all learned publicly about the secret life that she lived, as particularly in reference to her association with Diddy, how that relationship developed and what it was all about. Now that we have established that, the question is the logical question for the criminal defense, which they have not incorporated or used yet, and I don't know why, nor has the media picked up on this. When did we know, particularly the employees or co-conspirators, when did they know that Ms. Ventura was involved in messy work? You understand? That's how this works, because if the employees or co-conspirators had no knowledge nor intent to commit a crime by following whatever Mr. Combs bossed them around to do, then you lack one of the keys to calling this a RICO case. So my question to the AI was, let's see if I can get the question. You have to excuse the construction going on in the area. Lastly, if a pattern is established that these things are happening behind closed doors, that's the messy work, behind closed doors, and certainly Ventura as a messy worker has never been established amongst any employees or the public until now. That's my point. Therefore, the prosecution has not established a prima facie case for messy trafficking. Get it? Got it. Good. Here's the response from the AI. You're absolutely right to target the prima facie standard for establishing a messy trafficking charge, especially under RICO or 18 USC section 1591, federal mess trafficking statute. The prosecution must do much more than suggest something might have happened. Remember, if RICO don't fit, you must acquit. So you just can't say this, suggest that something might have happened in that aligns with messy work or messy trafficking. You have to prove, and your witnesses have to be the ones to tell you that. Now, before any witness gets off that stand in cross-examination, the defense team should make sure, did you know that Ms. Ventura is engaged in messy work with Mr. Combs? When did you find out? If yes, and if you didn't know that, how? Get off the stand. Goodbye. Have a nice day. Our cross-examination is over. You don't have to make the cross-examination series of long questions. You have to know when did the person that's the witness testifying knew that she was part of messy work? And I'm pretty sure that most people didn't know that. They may have known about the domestic violence, but the statute of limitations is gone on that. If RICO doesn't fit, you must acquit. So remember, under the RICO, 18 USC section 1591. Take it to a lawyer and see if they give you an answer. The prosecution must do much more than suggest something might have happened behind closed doors. And knowledge and intent is what those co-conspirators, which they still haven't mentioned. Knowledge and intent is the question or burden of proof on the prosecutors. So don't let nobody off the stand unless they knew about the messy work relation with Mr. Combs. And if they didn't know, there's no RICO. If they didn't know, there's no RICO, and therefore you must acquit. How about that? I'm a rapper. I'm not a lawyer. So consult your lawyer on that. What is a prima facie case for messy trafficking? Under 18 USC section 1591, prosecution must establish, even at a preliminary level, that a person knowingly recruited, enforced, enticed, harbored, transported, provided, obtained, maintained, or benefited from a person for the purpose of a commercial messy act. 2, with knowledge or reckless disregard of the fact that force, fraud, or coercion, which we'll get into those 3, force, fraud, and coercion, FFC, would be used to cause the person to engage in commercial mess acts, or the person was under 18. Miss Ventura was 19 when she met Diddy, and somehow the relationship evolved into what is coming out in the courts now. So that all wouldn't apply, but prosecution is using section 1591, subparagraph 2. If knowledge or reckless disregard of the fact that force, fraud, or coercion would be used to cause the person to engage in commercial messy acts. So the RICO strictly establishes, which is why this case should not have gone forward. It strictly establishes that the conspirators and even Mr. Combs must have knowledge of a reckless intent, criminal intent. What weakens the prima facie case? No established knowledge among employees or public. Thank you. That's what I've been saying. If the nature of Ventura's activities was believed to be music, modeling, what we know Miss Ventura for is music, modeling, and consensual companionship, at least in the public eye. So everybody that gets on the stand for the prosecution should be told by the defense on cross, did you know that Miss Ventura did she confide in you in terms of the messy proclivities that she was engaged in with Mr. Combs? And if no, goodbye, get off the stand. Have a nice day. No further questions, Your Honor. Don't draw this out. You don't have to pressure anybody into any lie. The truth is better than the lie. And if the RICO doesn't fit, you must acquit. No commercial messy act proven. If they haven't established this, then they don't have a federal case. No commercial messy act proven. If there's no documentation, payments, or quid pro quo involving Ventura being exchanged for mess in a commercial capacity, this undercuts the commercial element entirely. But here's the main point. No force, fraud, or coercion shown prior to her claims. Now, if she's inviting, paying for, and all arranging these messy offs, then there's no force, fraud, or coercion. Now, some people would say it's a psychological manipulation. At 19, it surely can be. The brain doesn't develop until you're 25. And once again, we're not minimizing anything that may have happened. What we are saying is that it's not illegal, that you made some messed up decisions in your life as a young lady. No fault, no blame, no shame, and no crime. Behind closed doors, conduct is not enough. See, the only thing we have is Miss Ventura's testimony. We don't have anybody mentioning anything about, did you know that there was messy trafficking going on? What knowledge do you have of that? Cross-examination, defense, why aren't you asking these questions? It's a simple one question answer. You ain't got to go through all this. It should be easy. 3, this is still under USC 18, section 1591. Number 3, prosecution burden versus speculation. At present, no matter even as powerful a witness as Ms. Ventura was, we don't have any establishment of messy traffic. We have messy workers, one of which would be Miss Ventura, if she's being forced, as it is claimed by the prosecution, then she's part of that messy work, right? According to them, which would make what Mr. Combs did criminal and beyond a statute of limitation. But they haven't proven that. This is just speculation. The prosecution must represent evidence, not speculation, not suggestion, not inferences, not just implications. Concrete examples of coerced, messy acts tied to financial gain. The financial gain is there, but the people involved in the messy acts have a choice. They have a choice to deny it. They have a choice to say, I'm going to do better with my life. I'm not going to be engaged in these messy works. That's a choice. Knowledge by others, messy workers, that they were facilitating or covering up criminal conduct. They have not proved that, nor can they prove that. Consistent pattern of behavior that rises to the level of organized, knowing trafficking. Nobody understands, and you can't let them go off the stand as the defense without asking each person that same question. Did you know that there was messy work trafficking going on? If they can't answer that, goodbye. Have a nice day. If the prosecution relies solely on Ventura's testimony without corroborating evidence or pre-existing knowledge among employees, then they have not met the prima facie threshold. Strategic defense argument. The prosecution has alleged a pattern without presenting proof that any employee, contractor, or member of the public understood Cassie Ventura's role to be that of a trafficked individual. So in order for them to commit a crime knowingly and with intent to commit a criminal act, they would have to know that she's a messy worker. She's only known as a model, an entertainer, a media mogul, not a person that's into messy work. So how could they know that if I ordered a ticket for, or I was the bodyguard for the night of this event, and I may have even heard some commotion going on? It's not my business to answer as a security guard. We went over that yesterday. At best, the allegations represent private conduct, later interpreted as coercive but not demonstrable, known enterprise involving commercial mess. Without knowledge or commercial benefit, there is no trafficking and RICO predicate offense. So that's where we're at. And that was part of part 2, defense strategy. So now, what the letters over the weekend that went to the judge for adjudication, I don't know how those letters turned out, but they could strike under the RICO rules, under the federal rules of court procedures. They could strike Ms. Ventura's testimony altogether if it can be proved that the judge rushed the cross-examination of Ms. Ventura. Now, why would you put somebody on the stand that's 8.5, not 8 months, 8.5 months pregnant, not knowing how long her testimony would be? I don't know if it's for the prosecutors or the defense for not allotting enough time for cross-examination, because a lot of things that Ms. Ventura said were not challenged, and we're not minimizing what happened to her. Remember that. But if the RICO doesn't fit, you must acquit. Here's what the defense strategy should be: undermining the RICO without villainizing the victim, Ms. Ventura. Emphasize the difference between private abuse and criminal conspiracy. This was private abuse. It should have been taken care of in state court. But you don't want to go to state prison, believe me. Key line: even if Mr. Combs did wrong, and even if we accept Cassie Ventura's testimony as true, that doesn't make it a criminal enterprise. Strategy: frame the alleged acts as isolated, private, and concealed from others. Ask everybody on that prosecution's team in cross-examination, did you have knowledge of any messy trafficking? And did you have any knowledge that Ms. Ventura was engaging in messy acts? Did you know that? If so, how much, to what extent did you have knowledge of that? Argue that these acts do not constitute systematic, profit-driven, enterprise-level behavior, and even less so, one that the other people knew about. Emphasize the lack of knowledge and shared intent among organization staff constitutes no RICO Act. If there's no RICO, there's no case for the prosecution. 2, attack the enterprise element of RICO. This is what should be attacked. No reporter, no defense team are even bringing this up. Attack the enterprise. You don't have to attack the victim. Attack the notion that this was an enterprise. Under the RICO prosecution, under RICO, the prosecution must prove an ongoing organization. Bad Boys was an ongoing criminal organization. You don't believe that's true. You big dummies that's talking about, oh, this is a criminal. Bad Boys evolved into a criminal organization. You don't know what the hell you're talking about. Associates functioning as continuing unit. Where can they prove that? All the people that's been fired, all of the former employees. There was an interview with a bodyguard the other day. He said he didn't know nothing about this. And this was the time in which he worked and knew Miss Ventura. He didn't know nothing about that. Engage in a pattern of racketeering activity. That's very hard to prove, particularly in a case like this where the statute of limitations is up. And because of the secret relationship of Miss Ventura, there's no knowledge and intent. This is not an enterprise. This is a celebrity private entourage. Where's the evidence of a hierarchy structure, directive, shared criminal purpose? Diddy was the general, who were the soldiers? The private agencies that he hired as messy workers to come and have messy activities with Miss Ventura, that's a private entity. Those were private entities that they solicited, not part of Diddy's team. They can't prove that, no way, no how. That's what is missing from the media reports. Nobody's getting this right. But this is not my fight. I'm just pointing out the obvious. But it seems conspiratorial that they would, including the media, including the public opinion, nobody wants to talk about this. I did see one lawyer, and I'm hoping, not a lawyer, a YouTube channel out here surviving the, I gotta see if I can find that guy. Because the guest panel that he had on addressed all of this nonsense. Part of the defense strategy number 3, undermine Ventura's role as a commercial messy worker. Yeah. This is the strategy. Emphasize Ventura was perceived publicly and privately by the staff as entertainment, a model, a singer, an entertainer, and a model, not as a Mex worker. Combs' partner, artist, and collaborator is what she was. As any of the prosecutor's witnesses in cross examination, whether they knew her as anything other than Combs' partner and an artist for the Bad Boys or a collaborator. Ask them that. Don't let them get off the stand without that. Not someone who was commercially trafficked for messy stuff. No staff member, no vendor, no witness ever testified that they viewed Miss Ventura as a messy worker. How can someone conspire in a trafficking ring they didn't even know existed? You see, it's common sense, common logic of defense team. First year law student can figure this out. The fact that no one is saying anything should be alarming. Mr. Combs must have pissed off some people very high up in order for all of the media, all of the prosecution, and all the judge to the very judge, Mr. Superman, Mania, whatever damn name is. All of them are trying to speed up this trial when it needs to be slowed down and give the defense a time to figure this out. Because it should be obvious though, but who knows? Number 4 of the defense strategy, shield the employees. No knowledge, no intent, there's no crime. No knowledge, no intent, then no RICO. Simple. Make this your chorus. The prosecution has not shown that anyone, bodyguards, assistants, drivers, knew, intended, or acted in support of the criminal plan. What criminal plan? Without knowledge and agreement, there is no conspiracy. Without a conspiracy, there is no RICO, and you must acquit. Or maybe he probably did this shit. Well, probably is the reverse of reasonable doubt. They're intertwined. They're inextricably intertwined. Use this to isolate Combs as a possible lone offender, which is what it was in the first place. And if you want to do something to Diddy, because of that, you have to respect the statute of limitations and the delay. Disarm RICO by removing the pattern and enterprise framework that they're trying to suggest as the prosecutor. 5, mid-trial motions and jury strategy. Tactical tools, motion for judgment of acquittal, rule number 29. After the prosecution rests, ask for dismissal of charges against staff or lower tier defendants. There are no lower tier defendants. How are you going to have a case with a conspiracy of bad boy and no defendants? Oh, they're all working for the prosecutor, right? And testifying for the prosecuted for immunity. Then ask those prosecutors' witnesses, did they know of any messy work, traffic? Request limiting instructions to prevent the jury from conflating Combs' conduct with the liability of others. During cross-examination, ask, did you ever hear anyone say Miss Ventura was being trafficked? Were you told she was doing messy work? Did you ever receive payment related to any messy services she provided? Force the prosecution's witnesses to admit no one knew anything. Conclusion, the defense should concede nothing about Combs' private behavior, but sever it from the conspiracy theory. The moment the government case relies on people should have known, or it was happening behind closed doors, they've lost the certainty needed for a RICO conviction. Now, let somebody that's a lawyer, attorney, look at this video and tell me if it makes sense. Because I'm not an attorney. And the judge's name is Subramanian. Subramanian. Superman. Subramanian. So my next question to AI was, I guess I gotta read this. So this is the letter. The letter that was written by the defense as a counterclaim would suggest that they can go for a motion to strike Mrs. Ventura's testimony because they were not allotted enough time because Mr. Judge Subramanian did not or directed the defense team that they had to speed it up in cross-examination of Ms. Ventura. If that is the case on appeal, the case would have to go back down to the lower courts because you can't speed up a trial. You're not knowing what the witness is going to say. You can't predict that beforehand. So if during her testimony she says something that needs to be checked, then you have to be able to check it, and you have to be allotted enough time to check it. I'll leave that alone. I think we're past that part. Because they're going to let Mrs. Ventura's testimony remain. Now the defense can call her back to the stand as a hostile witness, but she would have to be resubpoenaed for the defense. So that purpose of that motion was defense is asking the court to prohibit government's witness, including Cassie Ventura, from speaking with anyone, including their attorneys. That's what that letter was about. It was seeming to the defense team that she was being coached by her personal attorney during her testimony. That would be illegal. So that letter is a motion to tactically sound preemptive strike against credibility and perceived spontaneity of Ventura's testimony. It serves both to protect the defense's cross-examination rights and undermine the prosecutor's portrayal of a unified known conspiracy involving the entire Combs enterprise. So Combs may be guilty of abuse, but unless others knew of or participated in criminal conduct, there is no RICO conspiracy. Aligns very closely with the strategic and constitutional argument made in the motion to Judge Subramanian. All right, I don't want to bore you anymore. If you have an attorney, this would be a good question to ask him to review this video so that you can have some insight. Because a lot of people are talking about, I don't doubt that the federal government wants him in jail. I don't doubt that at all. I don't think that they can legally do it. That is my argument. So thank you for listening. There'll be a lot more testimony. People should be coming out of the court shortly, if they're not already out. I see a crowd down there. You see it? I'm going that way. I see the attorney for Miss Ventura right over there. Wow. It's my first time seeing him up close. They're coming up now. See everybody trying to go film them.
I can't run.
And to get the dog on somebody. I ain't chasing nobody. Know who the hell that is, but it's somebody important that everybody is chasing.
Back up water.
This is Sean Puffy Tone trial. I think they let somebody out. Must be a witness who testified against Mr. Combs. I think I see somebody. I don't know who it is. All right. We are gonna call it a day. You know, this is the courthouse where you get married. So a lot of people are out here getting married. Another hard day's work, no pay. It's nice out here in the sun, but you don't need to be in that shade. You really feel it. You actually need a jacket a light coat. I think I'm gonna go over there, have a seat.
Because I asked that in the meeting about voter blood money.
Okay. Let's end this live. Recoup another day. Thank you for watching. Peace to the universe.